hope everyone can see my screen. Okay, so welcome to the Ultimate Guide to Divorce in Maryland. I'm Dana Whitten. I am an attorney. I'm in Rockville, Maryland. My office is right by the courthouse. I can see it from here through the rain. Like I said, I hope everyone's having a nice day. And yeah, let's get started. So today we're going to be covering divorce, child custody, child support, alimony, property division. Well, I'm not going to be discussing protective orders today, but I am going to be discussing separation agreements. So I just wanted to congratulate all of you on being here. This is the first step towards preparing yourself for divorce, educating yourself for divorce, and I just want to acknowledge that I know that this is hard, but hopefully we can move through it together, and you should all be very proud of yourself for showing up today. So there are two types of divorce in Maryland. If you've done some Googling, you may already be aware of this. There's a limited divorce and an absolute divorce. And before I jump into the remainder of this presentation, a few of you asked me some questions, specific questions about divorce and child custody, and so I will be addressing those at the end. So as I was saying, there's two types of divorce. We've got limited and absolute divorce. In order to get divorced in Maryland, you need to have lived in Maryland for at least 6 months prior to filing. So if you lived in Virginia and then you moved to Maryland and you've only lived in Maryland for 3 months, that means that you have to file for divorce in Virginia, if that makes sense. And the same for child custody as well. You need 6 months in order for Maryland to have jurisdiction over your custody case or your divorce case. And also, the grounds for divorce must have also occurred in Maryland as well. And so we've got two types of grounds for a divorce. We've got no-fault divorce and a fault divorce. For no-fault grounds or no-fault divorce, you're either separated for 12 months or you can ask the court for divorce by mutual consent, and that's when you reach an agreement with your spouse. I will be discussing that later in this presentation. So there's 7 fault-based grounds that can be cited when you file for divorce, and you will need to prove one or more of them before a divorce will be granted by the judge. 1 is cruelty of treatment, 2 is excessively vicious conduct, 3 is adultery, 4 we've got desertion. There's insanity, conviction of a crime, involuntary separation for at least 12 months. The cruelty of treatment and excessively vicious conduct, that usually goes hand in hand with the filing of a protective order. That's Maryland's version of a restraining order. That's usually what it's called in movies. Adultery, that's obvious. The insanity piece, you need a court order for that. You can't just say my spouse is crazy, so I need a divorce. The conviction of a crime would also involve a period of incarceration. So moving on to what an absolute divorce means. An absolute divorce means that you are no longer married to your spouse, which means you can remarry. And so there are a number of fault-based grounds for absolute divorce, but you still have a requirement for all of them that you be separated for at least a year, other than the by mutual consent, which is the second one. So you can't be living together by the time you have living together or have had sexual relations with your spouse by the time you get to court and ask for an absolute divorce. And that makes sense, because how is a judge going to give one person custody and the other while you're living with your spouse, or child support or alimony? And so that would make sense. You still have to be separated, even if you have one of these grounds for divorce. Okay. So then we've got also a limited divorce. Okay, and that's just a legal separation. I very rarely see that someone that has gone through the court system all the way and only gotten a limited divorce. A limited divorce means you cannot remarry. It's a legal separation, but you want to file for a limited divorce if you don't meet the requirements for an absolute divorce. A limited divorce allows you to still have some of the same rights that you would have if under the absolute divorce statute, but a limited divorce allows you to get child support. It allows you to get alimony, but it will not allow you to get property division, which I will touch on later. But my next slide covers, this is the important piece. So let's say you separated from your spouse, but you've only been separated for about a month. You call a lawyer, me ideally, and you would have grounds just for a limited divorce. Filing for a limited divorce allows you to get your foot in the door so that you can earmark, child support, a request for alimony, a request for custody, but it allows you to get in the court so that eventually, by the time that the hearing happens, you'll most likely be separated for 12 months, and you can easily turn your request for a limited divorce into an absolute divorce because you have been separated for 12 months. So I currently have a case, and my client and his wife and they have a set of twins. They were all living together, and they were living in a rental property, and I represent Dad, and the wife said, at the end of the lease term, I want to separate. So he had called me, and we actually had been working together for a couple months prior to actually the end of the lease. And so I would encourage you all to do that as well. And so by the time the lease was up, he had a place to live because I told him that he needed to find a residence within the children's school district, but he had a place to go. And so we were able to file a limited divorce based on just separation less than 12 months. So there was no abuse, no cruelty of treatment. He might argue with me that there was a lot of yelling going on in the marriage, but that's not enough for those two grounds, as I had indicated earlier. So right now he only has grounds for a limited divorce, but our trial is not set until February of next year. So his grounds for his 1 year separation will be August of 2023. And so we will simply amend our limited divorce complaint to an absolute divorce complaint. And so by the time we get to our trial in February, he will be eligible for his absolute divorce, and get all of the relief that he could have with the absolute divorce versus a limited. So as I indicated with my current client, he hired me long before he and his spouse had actually separated. And so these are six steps that you should consider taking now to, one, hire a lawyer, just like my client did in the example that I gave you, or alternatively, educate yourself. But do not represent yourself. I can't emphasize that enough. I've had clients that come to me and they unfortunately decided to represent themselves and had not such good luck because maybe their spouse had a lawyer and they didn't. But it's more costly to fix an issue or issues that happen when you didn't represent yourself than it would be if you had just hired a lawyer to begin with. You want to organize your finances. And when I say this, I don't mean you need to print out all of these things, but I would have readily available 6 months of bank statements, credit card statements, quarterly statements for your retirement, or a recent statement, and a recent IRA statement, just so you can get an idea of what your finances are. You also want, for purposes of your attorney, tax returns if you have access to them, and also your last couple. I usually ask for last 4 pay stubs. You also want to make a list of personal property. You can do this either by actually, writing out a list, putting a list in your phone. Easiest way though is to take photographs, and that's just so in case anything goes missing, you will have proof of it on your phone. And your phone, is pretty valuable because it has the date and time that the photo was taken. So you can say, well, look, this really expensive piece of artwork was once in my home and it's not in my home anymore, and somehow it disappeared, and that will be taken into consideration by the judge later on with the property division piece, which I will discuss shortly. So you want to create a budget. This is really important for your post-divorce living expenses. So I'm including, along with my ebook, a long form financial statement, which is a court form, but it's actually really helpful, and I use it for my own personal expenses. But it's a document that gives you line item monthly expenses for your whole life. It's got mortgage, and a space for you to put the amount, mortgage, taxes, insurance, your car payments, gas, everything. It's really helpful, and it's a great way to budget to see, what your life would be like, post separation, post divorce. You also want to remember to change your beneficiary designation and power of attorney. A lot of people, which would make sense, when you get married, you would identify your spouse as a beneficiary, or if you drafted estate planning paperwork, you had your spouse involved in decisions if you were to become incapacitated. And so you want to be sure to change those or update them to someone else, a family member, a friend, someone that you trust. And lastly, you want to prioritize your mental health. And it's just important to remember that what you say to family members and to friends about your divorce, or any complaints you have, or whatever, it's not privileged. What you say to your therapist is privileged. And this isn't a plug, but I would just suggest, I know that therapy can be costly, so I would suggest BetterHelp. It's like $80 a session. That's where that's what I suggest to my clients if they need therapy. You don't necessarily need therapy, but it's just important to remember to really find a good support network. And even if that's friends and family, that's fine. But just remember that they can be called to court to say the things that you've told them, good or bad. Ideally, they're all good. But so don't forget, you'll also receive my ebook after this webinar, and it will also have more of a checklist for you to keep in mind when preparing for divorce. Okay, so how do you choose an attorney? This goes for both divorce and child custody cases. You want somebody who's going to be a good listener. You want somebody who's going to be an innovative thinker. This means that, not every case is the same. Kind of like, I like to consider them like fingerprints. While on the surface they look similar, but there's actually intricacies to everyone's case. No two cases are exactly the same. You want to check to see if they're an accomplished litigator or really just a litigator at all. Some attorneys do not like to go to court. I'm okay either way with settling or going to court, whatever best suits my client and the outcome and goals that they're seeking. But I have had cases with attorneys who clearly don't like being in court, and it would not benefit you to have someone that's more of a mediator type attorney. You want to ask yourself, do I like this lawyer? I think that's also really important. And also, are they a dedicated family law attorney? A lot of attorneys, and no shade to them, but a lot of attorneys, practice family law along with criminal, along with estate planning, along with immigration, along with, personal injury, medical malpractice. But family law can get complicated, and it is complex. And so I think it's important to pick an attorney who is a dedicated family law attorney, such as myself. Okay, so child custody. I understand that this won't necessarily apply to everyone, so hang tight, I guess, if you don't have children. But just so everyone knows, there's no automatic preference in the state of Maryland. Just because you're a mom doesn't mean you're automatically going to have custody. Just because you're a dad doesn't mean you're automatically not going to have custody. The court considers a number of factors, a lot of them, and they're from case law. So the court doesn't have to consider all of them, and there's about 20. So I'm not going over all 20 of them, but I encourage you all to Google them. Also, they are more expanded upon in my ebook. And the judge goes through these factors to determine what is in the child's best interest, or the best interest of the child. As I just said, there's a lot of factors, but some of the high point ones that the judges typically consider is who is the primary caregiver. I think this point, or this factor, is rare in 2023. Most families have mom and a dad, husband and wife that work. we're more of a 2-income household state, I would say, depending on where you live, but that's not always the case. But so the court will take into consideration who the primary caregiver is. I always like to ask my clients, you know, if your child was to wake up in the middle of the night and the child had a nightmare, who would they call out to, mom or dad? And so I've had dad say that it's me. I've had mom say it would be dad. I've had vice versa. Kids, you know, would say, you know, they would call out for mom. But so that's how usually I would exemplify that factor. Okay, so the physical and physiological health of each parent, that really goes to, you know, your ability, physical ability to take care of the children, and also character and reputation of each parent. These two factors can be proven in court by having good character witnesses, and that circles back to be careful what you say to your friends and family about yourself or about you know, the other parent. But with respect to character and reputation of each parent, this kind of goes to whether there's like alcohol abuse or substance abuse or mental health issues. Are there any existing agreements in place? Sometimes, and so when this factor doesn't necessarily mean written agreements, but have you guys been following some kind of status quo? The ability of each parent to maintain family relations for the child. This means, do you have good relationships with your spouses or other parents, in-laws, cousins, etc.? How's everyone getting along? It's not a determinative factor. None of these are in and of itself, but again, they're factors that the judge considers as a whole. The child's preference. This is an interesting one. So 9 times out of 10 in Maryland, judges abhor having children come into court and say what their preference is. This particular, I only had one case, and it was in Hartford County, and the judge wanted to speak with a 6-year-old boy, and my client said no. And so the judge said, well, I can't say what the child's preference is because I didn't interview the child. That's what a lot of the judges will say, even if the child's 18, which ideally we wouldn't be fighting over a custody of an 18-year-old, but it's unlikely that a judge would pull a child into court because of, you know, impacting the child's relationship with either parent. So this factor really goes to whether there's an attorney representing a child, also known as a best interest attorney, and that's how a judge can hear what the child's preference is. But that's a third attorney in the case, and outside of today's presentation. Financial resources of each parent, age, health, and gender of the child, proximity to the parents, living by one another, and also proximity of how close the parent lives to the child's school, especially if this child needs to be taken to school. That is one factor that can be an issue if if your child grew up in Montgomery County and you decide, you separate and you decide you want to live in Frederick County. Getting the child to school, after an overnight at your house in Frederick County or the house in Frederick County to Montgomery County is going to be a problem either way, just because of the 270 traffic. So I have seen that one litigated a lot. How long the child has been separated from the parent and a history of abandonment. So I will tell you this, I represented a woman who she was undiagnosed with bipolar type 2 disorder. And she had left her children for 18 months prior to calling me or anything. But she came back after 18 months. She got the appropriate medication and she left them with her husband. She got the appropriate medication, she got the appropriate therapy, psychologist, all of it. And so by the time dad was ready to file, mom had already been back and in her children's lives, actively taking care of them. And so he waited too long to file. If I was his lawyer, I would have told him to file sooner, but it worked out in my favor because I represented mom. And so mom was already completely reunited with her children by the time trial came around. So while the judge did touch on that, it was not a determinative factor and she got the same amount of custody as dad. So that's important to keep in mind. Okay, so there are two types of custody. There's physical custody and legal custody. Physical custody is who the child lives with on a day-to-day basis. That's the schedule that you've probably Googled. Is it 50-50 schedule? Is it every other weekend type schedule? Legal custody is who has the right to make a big picture decision for the child. And when I say big picture, it does not mean will Archie play the flute or the piano. That's not a major decision. It's a major decision impacting their health, education, and religion. And I just want to make the point that just because one parent has sole physical custody, let's say, or primary custody, because another parent lives in Frederick, like I said, that doesn't mean that you can't continue to make joint decisions together, so you can have, one parent can have primary physical custody while still having joint legal custody or decision making. So one does not impact the other. They're two different legal concepts. I will say that I've seen a big trend over the past maybe 2 years since this case came out, where the courts like to give joint legal custody with tie-breaking authority to one parent. And the thought process, I think, behind that, although I'm not a judge, is it reduces the likelihood that the parents would come back to court to argue over a legal custody decision. Like if one parent really thinks that the kid needs tutoring or an IEP and the other parent says whatever, it might be that they nip it in the bud the first time everyone comes to court that says, you know what, mom sounds like she's a little bit more in tune with education, so we're going to give her tie-breaking authority just on education decisions. So it can be tie-breaking authority on all decisions, or it can be tie-breaking authority on health, mental health included, education, and religion. And so I also wanted to give you this example. I represented a woman and she had primary custody. We were fighting over a 14-year-old daughter. And my client had primary custody. She is a nurse, and dad had every other weekend and I think a midweek dinner visit. Maybe one additional overnight, but mom had more overnights than dad. And the kids in this case went on for 2 years only because of COVID. Normally that's an abnormal example, but this case went on for a long time. And the kids' grades plummeted in a big way. A lot of kids' grades did because of COVID, but my client worked nights as a nurse, and so dad testified and said that he was always scrambling to help the kid with the homework during his time, and my client said, look, I'm doing the best I can. So it ended up, because my client had that medical background, that the judge said, all right, well, we're going to give dad tie-breaking authority on education decisions. Primary custody was still to mom, but dad's got tie-breaking authority on educational decisions, and mom has tie-breaking authority on medical decisions. And to this day, I haven't heard any issues from either of them about that, but that's a good example of how these two types of custody are not necessarily related. Okay, so calculating child support. Again, I apologize for the people that don't have children, but hang tight, we'll get through this. So I want to make sure that everyone understands that non-payment of child support does not mean that the person that's not paying can't see their child. It's two different concepts, if that makes sense, or two separate issues. And so when we calculate child support is supposed to represent the basic needs of a child while in the person who's receiving the money's care. So it's, and if you don't like it, talk to the legislature, but it's supposed to take into consideration the amount generally of, the cost of living, clothes, food, that's pretty much it. But the income shares model is based on the concept that the child should receive the same proportion of parental income that the child would have received in an intact family. So how much the parents would spend on the child if they were still together, it's like a proportionate share. But at the end of the day, it really comes down to a child support calculator, which we will get to in a second. So defining income. when we calculate child support in Maryland, you look at the gross income of the parent. I know everyone's upset about that. So you look at gross income of mom and dad, that means before taxes. So that's salaries and wages, commissions, bonuses. That's a big one that people argue about. Dividend income, pension income, interest income, trust income, annuity income, social security benefits, even workers' compensation, disability, unemployment insurance benefits. And so that all is taken into consideration. And it's before taxes, it's gross income. Okay, so now we get to the exciting piece, the actual calculator, or also known as Maryland Child Support Guidelines. And I should say that within my ebook that you'll be receiving after this presentation is a link to a free Maryland Child Support Calculator, so you can fiddle around with it yourself. So in order to use it, you will figure out each parent's gross income. So if they're paid 20 bucks an hour and they work 40 hours a week, it's $20 an hour times 40 hours a week times 52 weeks in the year, divide by 12, and that's monthly gross income. 2 is to figure out each parent's actual adjusted actual income or imputed income. Imputed income is when one parent isn't working intentionally to avoid child support payments. And you see that a lot. And so what do you do when that happens? Well, at a minimum, every judge in the state, I would say across the United States, expects a parent over the age of 18 who has a child to get a job. And so at a minimum, despite somebody being laid off or whatever, at a minimum, a judge is going to say, okay, you could be working at 7-Eleven or CVS earning minimum wage, and that's the imputed income piece. If you would like their income to be higher, you can kind of rely on their previous incomes from previous jobs that they've had, but the court will absolutely not run the child support guidelines at zero, like no way. So you would include mom's gross income, dad's gross income into the calculator. And then you also want to figure out health and cost of health insurance, cost of monthly daycare, any additional medical expenses that are not covered by insurance. This could include, and it's typically is orthodontia expenses, and also the cost for therapy, which usually isn't included or covered by insurance. And so, as I said, you want to take all these other items into play, and the calculator spits out an amount. A lot of people fight over it, but the calculator has been approved by the Maryland legislature. It's used by our courts, so you're stuck with that number. And the amount of child support also is impacted by the number of overnights. And that would make sense. If it's 50-50 custody, child support would be less than it would be if one parent had more overnights than the other parent. And the reason being is because it would cost the parent that has more overnights more money to take care of, feed, clothe, give shelter to the child than that parent would if it was 50-50 or vice versa. And just so everyone knows, child support is paid through 18 or when the child graduates from high school, but no more than 19 years. So if your child turns 18 in February of his senior year, you're still on the hook through your child's graduation. And again, if you only file a complaint for limited divorce, you can ask for child support. And so that's just another, and so it's important to the sooner you file for divorce, whether it's limited or absolute, the sooner you can ask for child support. And so when you make a formal complaint, when you file your complaint for limited or absolute, and you ask for child support, that time is earmarked so that every month that ticks by that your spouse or whoever doesn't pay, or maybe you're not paying, that date is the date and time that the court can award retroactive child support back to the date of filing. So if 5 months hasn't been paid, 5 months will be calculated, and they'll pay it out over time, usually absent somebody having like a lot of money to pay it off. But usually it's kind of how the court kind of lets you pay in increments the back amount owed. Sorry, I've got an environmentally friendly lights. Okay, so how is alimony determined? Back to everyone here that's here for divorce. I will say that alimony is different now than it was, the concept is different now than it was in 1950. And you can probably understand why it's 2023, that both spouses usually work. It's rare that they don't. And I do have a case now with a stay-at-home parent, so I will be discussing that as well. But in my opinion, and we're getting to, so the alimony factors, which we'll be getting to, that they're statutorily mandated, which means that the court has to go through all of them. With respect to custody, those are case law. I told you there's 20 of them. There's some that the judges can kind of pick and choose. But when it comes to the alimony factors, the judge has to go through all of them and has to take each and every one of them into consideration. In my opinion, alimony comes down to, does the person having more income than the other one have the ability to meet their own needs while having additional income to pay support to the person who's asking for it, if that makes sense. So we will get to that in a second. So there's 3 types of alimony. We've got alimony pendente lite. That's following, pendente lite is the first short court appearance that you will have once you file. And that's where you can ask for you ask the court to essentially put a Band-Aid on things. Pendente lite is Latin for the phrase meaning pending litigation, and that usually happens 3 months after you file for divorce, 3 to 5 months, I would say, after you file for divorce. And if you're asking for alimony, it's a moment in time that you can ask for temporary support until you can have your full-blown final trial on, whether the alimony is going to be rehabilitative or indefinite. And so the pendente lite alimony is just for purposes of putting a Band-Aid on the situation. So, for example, I have a client now who was a stay-at-home dad, and the stay-at-home dad, this is my first case where I've had this, he actually followed his wife's, and they have children, her career around. That took them to Europe, took them, to, I think, England, and then Germany, and then back here in Maryland. And so we were negotiating pendente lite alimony for him, alimony and child support. And so dad still isn't working. And dad has some limitations, physical limitations, but dad also hasn't worked in like 12 years. So for pendente lite purposes only, we got him a sum of monthly amount of money from wife to him for the support of him and the minor child. We kind of called it's called undifferentiated, but it's just a temporary amount of support to kind of hold him over until we can have a full hearing on how long alimony should continue after they get divorced. So that moves us into rehabilitative or indefinite alimony. I'm going to be very straightforward with all of you. It's very difficult, in my opinion, to get indefinite alimony in 2023. The reason being is, again, we're not in 1950. So it's more than likely both spouses work. However, and usually I would say a lot of people, they earn the same amount of income. However, there are some cases, and there is a unreported case that I'm very familiar with, where the husband was earning $1 million and the wife was earning $170,000, which is a great living. And the judge absolutely hated the husband and awarded the wife indefinite alimony in the amount of like $12,000 a month. It went up on appeal, came back. I think that they slashed it to about $6,000 a month. But when it comes to indefinite alimony, it needs to be disparate incomes, and that's what this slide talks about. Rehabilitative alimony is usually a lot more typical. And in the case where I had the client, or my client who was a nurse, she received rehabilitative alimony because the judge felt like she needed to go back to school because she had an associate's in nursing, and so the judge thought that she could make more money after, I think it was like 5 years. And so the judge afforded her that time to go back to school and get a college degree, not just an associate's in in nursing, and so that's up to her as to whether she wants to listen to the judge or just take what she's been given. But alimony is always modifiable, aside from the pendente lite one. Rehabilitative or indefinite, it's always modifiable, meaning you can come back to court and either ask for more or ask that it be less. Okay, so the alimony factors. So all of these have to be considered by the judge, like I said. So the length of the marriage is really important. So in the case with my client, who's the nurse, she was married for 20 years. Excuse me, 20 years. And the age and health of the parties, she was pretty young. She was 45, he was like 48. And she ultimately went back to work, but the judge thought she needed to go back to college to earn more income, which I didn't necessarily agree with, but here we are. Okay, so the ability of the party who is seeking alimony to be wholly or partly self-supporting. This is back to my client who has the associates in nursing as opposed to a college degree. So the judge gave her time to go back to school to become more self-supporting. The reasons for the parties' estrangement and divorce. This is where adultery comes into play. I'd like to say it's 2023 and who really cares about adultery, but it can, I have seen a court allow the adultery piece to impact their decision in terms of amount and duration is what I would say. But that's something to keep in mind. So the standard of living established during the marriage, in the case with the husband making $1 million a year and the wife making $175,000 a year, they were members of country clubs. They drove his and hers Porsches. You know, they were living, I think the quote from the judge is that life was on easy street. And so I know that the judge had taken that into consideration when awarding her. That's a woman who got the indefinite alimony award. The length of time it would take one party to be self-supporting, again, that's my nursing case, and she's given the opportunity to kind of go back to school, should she so choose. The contributions, both monetary and non-monetary, of each party to the well-being of the family. This comes down to, you know, everyone's tasks. And this one is, you know, this would be like a stay-at-home mom who supported her husband's career, kind of like my client who, you know, traveled the world with his wife to support her career. They have twins. And so, you know, he had to put his career on hold, or I think they might have reached an agreement that said he will, you know, stay at home with the kids. But so the contributions, so his contribution would not be monetary because he's stay-at-home dad. It would be non-monetary, laundry, doing, you know, cooking, cleaning, taking care of the kids. Income and assets, including property that each person has, retirement benefits everyone has, and the last one, which I think is most important, the ability of the party whom alimony is sought to meet his or her own needs while meeting the needs of the party seeking alimony. So again, that comes down to how much does everyone have in income? Can the person that's looking, that might have to pay it, can that person cover their own needs while also having extra to give to their spouse? Okay, so our final topic is property division. And it's important to note that Maryland is not a 50-50 state. It's an equitable distribution state, which is vague, which is why you should hire an attorney if it comes to property division. But what does equitable division state mean? It means that the court, depending on the circumstances, can award a little more to one party than the other, as opposed to it being 50-50, 60-40, something like that. The likelihood of that happening is slim, but it's possible. So you're in the right place. So what does the court consider to be property? It's obvious things like houses, cars, bank accounts, jewelry, furniture, and art. But it also includes businesses, business interests, business investments, trademarks, patents. So I'm just going to say this across the board. If your spouse or you work for, or you own a business, or your spouse owns a business, or there's any kind of business involved, not that you're a W-2 owner, but like you own the business, hire a lawyer. If there's a huge inheritance and that's been paid out or it's going to get paid out, hire a lawyer. And this is why. So we've got marital property. So Maryland courts only divide marital property, okay? And that's property that was acquired by one or both parties during the marriage. And that includes, like I said, real property. That can also include businesses. And depending on how the inheritance was handled, an inheritance may become marital property, and I'll get to that in a second. So non-marital property is separate property that is not subject to court division, that was either acquired before the marriage, acquired by inheritance or gift from a third party, is excluded by a valid agreement, or is directly traceable to any of those sources. So here's what I mean about an inheritance. Let's say that your aunt Hilda dies, and she gives you $40,000, and you decide, and so that would initially, it's non-marital property. But if you were to put the $40,000 into your joint account, you may have a problem in that Aunt Hilda's inheritance is now marital property and subject to division, unless you can kind of directly trace all the funds that went in and out. But you would absolutely need to hire an attorney in those cases. Back to monetary awards, how are they awarded? How is it divided? Again, it's an equitable distribution state, and these are mandatory factors. Again, it's likely going to be 50-50. I've rarely seen it be anything other than that. So I will say these factors are very similar to the alimony factors. But so the monetary and non-monetary contributions of the well-being of the family, the value of all the property interests of each party, the economic circumstances of each party at the time the award is to be made, the circumstances that contributed to the breakdown of the marriage, as I discussed, adultery. Big ones, duration of the marriage and age of each party, because if we have one, spouse who worked, the other one didn't, the working spouse accumulated a lot of retirement assets, maybe stock options with where they worked, and the other spouse does not have the same ability to earn as much. Maybe then it might be offset in a fashion where it would not be 50-50, but in all likelihood, it's going to be 50-50. The physical and mental condition each party, how and when specific marital property was acquired, and the effort expended by each party in accumulating the marital property. So that kind of goes back to my client whose wife was taken, they followed her career across Europe and everywhere else. So he's not going to end up with zero just because he was the stay-at-home dad. This goes to the contribution by either party to the acquisition of real property held by the parties as tenants by entirety. And then any alimony award also gets taken into consideration when awarding a monetary award. And so monetary awards are financial awards of marital property intended to compensate essentially a spouse who holds title to less than 50-50 of the property. But so this is why it's important to hire an attorney when it comes to property issues, because again, it's not always 50-50, and there might be a reason that you can lobby for more than 50-50. Okay, so why we're all here. The fastest and cheapest way to get divorced in Maryland. So now that you graciously sat through all of that information, the fastest and easiest way to get divorced in Maryland is by no fault uncontested divorce. This happens if there's a 12-month separation and you don't have a lot of property and you just file to get into court and a judge can just decide. Alternatively, and more than likely, you can file on the grounds of mutual consent, which is absolutely the faster option. And I did, did a lot of mutual consent divorces during COVID. People called me and they said, well, we've reached an agreement on all issues surrounding the marriage. We just want a divorce. So I would write up simple agreements for them depending on what property they had, but they had already almost predetermined kind of what they wanted. I was able to memorialize what they wanted in an agreement. They signed it. Eventually, during COVID, they got a hearing. It was over Zoom, and that would be like my first time meeting some of them. But so steps to reach an agreement. So you want to, in the agreement, you'll want to divide marital property and debts. You'll want to figure out what we're doing about alimony. Is one of you getting alimony? Are we waiving alimony? But alimony needs to be addressed. If there's children, you need to discuss how child custody and child support will be handled. If you reach an agreement by mutual consent, but I should just say if you reach an agreement and it's signed, you do not have to wait 12 months in order to file for an absolute divorce. They cut that out a couple years ago. So this is a streamlined way to get yourself divorced. So once you reach an agreement, ideally you would hire me or another attorney, and then there's going to be some negotiating going on back and forth. And then let's say we get the agreement signed. Fantastic. Now we've got to actually file it with the court. In my experience, what I like to try and do, even if the other side's pro se, the moving party, whoever wants to do it, has to pay a filing fee of like $165. But there needs to be a complaint. The spouse needs to file an answer. And then you are requesting a divorce by mutual consent, and you file your agreement. So you can file all of those things together at the same time, and then ideally, and then you will have an uncontested divorce date. You can, if not everybody wants to work together, if you got your signed agreement, alternatively, you still need to file a complaint in order to open the case in Maryland. The others, you can have to serve the other side. They've got 30 days to file an answer. But in my experience, I usually have everyone working together, because if we've already reached an agreement that resolves all issues surrounding the marriage, both people want the divorce at this point. So it's smooth sailing after that for the most part. And then you'll attend a brief Zoom 10-minute hearing. Although depending on what county you're in, some of them are still doing in person, but it'll still be a brief hearing. And the hearing is just the spouse who filed the complaint for divorce shows up, and they're asked a couple questions. Have you been a resident of the state of Maryland up to 6 months prior to filing your complaint? The answer is yes. What's your date of marriage? Did you reach this agreement? Does this agreement resolve all the issues surrounding the marriage, including property distribution, alimony, waiver, or otherwise? Does it resolve all custody issues? Ideally, the answer is yes. And then you are granted a divorce. How long does this in total take? 2 to 3 months. And I say that only because of the negotiating piece, because it takes two to tango, right? So I historically I'll draft for my client. My client will say, okay, this is what I want, or I spoke with my spouses and this is what we want. Okay, so I'll draft an agreement. The other spouse might take some time to find a lawyer. Then maybe there's some going back and forth. Not everyone's on top of things all the time, but that's why I would tell you 2 to 3 months. And this is only if you're able to reach an agreement. Because again, it's like waiting for a response from the other side. So ultimately, once you have everything together, when we've got our signed agreement, we've got our complaint and our answer and everything ready to go, we file it all in the court. And then after you file, it takes about 30 days. I want to say 30 to 60 days. And that all depends on the court's availability of their calendar. If you're filing like December 15th and you want to get in, before the end of the year, you want your uncontested divorce before the end of the year. I mean, that's fingers crossed, white knuckle, hope and a prayer that it all works out. But typically, once you file, it takes about 30 days in order for the court to say, okay, and they'll send out dates for your uncontested divorce hearing, then you have your hearing, and then you're all done. And so that would be the cheapest and quickest way to get divorced. Okay, so thank you all for attending. I do have, if you want to stick around, please do. Some of you submitted questions, and so I'm going to do my best to answer them. And also, if you have any more questions about things that I said today, things that are in my ebook, anything else that you want to discuss, I am offering a reduced initial consultation fee for people that attended this webinar, and I will send an email following this webinar with instructions for how to get that. Okay, so a very popular question is, how can I, let's see, my spouse doesn't want to leave the house. Is there a way that we can separate? What do I do, basically, right? So you're married and you want a divorce and your spouse still won't leave. I thought a lot about this just because so many of you asked, and there's no, I don't have an answer. There's no magic answer, but I can say you should lean on family members, lean on friends, see if they'll loan you money, and see if they'll help you obtain alternative housing. Is there a way to find affordable housing? Absolutely, but that would require some research on your part because everyone's different. But affordable housing does exist. I would not suggest a shelter, but you know, I'm sorry that I don't have a magic wand to answer that question, but friends and family have helped my clients. And so I'll give you another example. Another woman had been married for 20 years, and at year 12, she told her husband that, I don't want to be married to you anymore. And he said, he actually told her that, well, you can't divorce me. Who's going to give you custody of our children? You don't have a job. So she said, okay. So she stayed. And so she went and got her nursing degree. Another nurse got her nursing degree and worked very hard. And it took her a couple years because she was the primary parent for these children. Took her a couple of years. I met her at year 20 of her marriage, and she was ready to go. But she had a degree. She had bettered herself. She was ready for employment. Now, she actually ended up staying with a girlfriend of hers, who was also, interestingly, my client, a previous client. But the two families kind of lived together, like Three's Company, lives together in this larger, nice house. But so that they had, family meals and stuff like that. And they're still very good friends to this day. But that was how she got out, was that she got a degree and moved forward with her life that way. Okay, do I have advice or tips? The next question, next popular question is advice or tips for divorcing a narcissist. Okay. Yes, I do. Number one, the narcissist will never understand why you're unhappy, why what they're doing to you is wrong, that they won't understand that they might be emotionally abusing you. They take no accountability, and they'll never be sorry. So what's my advice is to just rip off the Band-Aid. Now, how do you, and just leave with your, if there's children involved, that gets stickier, obviously. But recording things via email, writing emails to yourself is helpful. Unfortunately, in Maryland, it's a two-party, consent state in order to record somebody else. So you can't record them without the other person having consent. Even if you do, it's a crime, but most importantly is you won't be able to use it in court. But I've seen people email themselves what was said to them, what happened in the moment. And then we were able to use, those emails to refresh my client's recollection about what her marriage was like. But if you are in a relationship with a narcissist, I do again suggest, back to what I said in the beginning, to get therapy. BetterHelp is good. I think Cerebral is another one. But so just know that they'll never be sorry. They'll never hold themselves accountable. It will always be your fault. But knowing that, I think, is powerful. But I think a mental health provider can probably also guide you in terms of being able to navigate co-parenting with a narcissist, which would be very difficult. I'm a business owner. Next question is, I'm a business owner. Do I have rights to my business, or will this be divided during property division? It all depends. It all depends. If you are a business owner, you should reach out to me because the question is maybe. I need more information from you on that. This is a good question. Can my ex-husband stop working in order to avoid child support? I touched on that earlier. He can try, but a judge is going to expect a functioning adult human to have that has previously had a job where there's no intervening act, like he got hit by a bus or something. He will expect them to, like I said, at a minimum, earn minimum wage. Alternatively, or you can say, look, he was making, here he is, he left his job voluntarily, and I have all the paperwork because you hired a lawyer, me, and we were able to get that paperwork, and he left voluntarily after I filed for custody and child support, or after I filed for divorce. He last was making $80,000 a year. We can ask the judge to treat him as if he's still making $80,000 a year. Now, ideally, the thought behind that is that would encourage him to go back to work. But there's ways, if he still maintains I can't pay or whatever, it is hard to squeeze blood out of a turnip, but they do have, or every county has a child support enforcement, and they're an arm of the court. They can do fancier things than I can do, like if your ex-husband is not paying child support, they can suck up his tax refund, they can cancel his passport and cancel his driver's license. I've seen that happen a lot, and so until they pay like a certain amount and then they get it back. But that's ways that they can kind of squeeze the spouse who's trying to avoid child support into paying. And that's a free service. And if you have more questions about that, again, feel free to reach out to me. Here's another question. I received an inheritance. I deposited into our joint bank account. If we get divorced, will I get that money back, or will it be divided between us? It kind of depends on how much is left. It kind of depends on how the funds were used. And I touched on that earlier. If there's an inheritance or if there's a business, you absolutely should call me or hire a lawyer. And we can talk through those issues and what that potential outcomes would look like. So that's all the questions that I have from you guys. Thank you very much for attending. I hope you found this educational, helpful, and you'll receive a copy of my ebook. And I'm also sending you the long form financial statement, which is crucial if you want to be able to financially prepare yourself for divorce. Like I said, I use it. Some of my colleagues use it just for personal reasons. It helps you kind of balance your life out and take, your income into consideration and what the expenses are that you have. So please reach out to me if you would like a consultation. As I said, I'll be emailing you shortly. And it was really nice to see all of you, or I guess I didn't see you, but thank you all for attending, and I look forward to hearing from you soon.